when we talk about hybrid offerings, what we're talking about are public offerings that have lots of characteristics or features that one would traditionally associate with private placements or with private or exempt offerings. One of the things that we do in the book is give a historical perspective on exempt offerings, on private placements, how they came to be, all of the different private placement exemptions, and give some practical insights about how to think about different offering exemptions. We kind of go in sequence. So we go from pipe transactions and structured pipe transactions to registered directs, to at-the-market offerings, to confidentially marketed public offerings. And we do it in that sequence because that's the sequence in which these deals came about, or these offering methodologies came about. This is the book that I wanted as an associate and didn't have. There is nothing else that looks in depth at the private markets or that really focuses on how to do deals in this way. It tells the whole history or evolution of an entire market and really how to do any one of these deals from start to finish, including giving you the forms to do it. So we do have a whole volume of forms. The forms follow in the order of the book from forms on private placements. So your basic accredited investor questionnaire, QUIB questionnaire, engagement letter forms for different types of placement agent, financial advisor engagements, to purchase agreement, subscription agreement forms, to pipe purchase agreement forms, to registered direct forms, to ATM forms, you name it, there's a form for it. We spend a fair bit of time in our book talking about the concept of securities law integration. So when securities lawyers think about integration, we always worry about securities offerings that are conducted in close proximity to one another. Often clients call us and companies are very focused on trying to raise money and to raise money in offerings that are conducted close in time to one another. Over the years, the SEC has really made great strides in terms of liberalizing the communications framework. In the book, again, we provide a historical perspective and lots of practical guidance on navigating communications rules in the context both of exempt offerings, but also some SEC registered offerings. This is a constant concern for lawyers. We often refer to the NASDAQ and the NYSE rule as the 20% rule, or the shareholder vote rule. Navigating those rules and knowing your way around those rules is incredibly important. Very important to familiarize oneself with the updated rules and to refer to some of the practice tools and pointers about structuring transactions given the new guidance. I think this was a particularly good time for a new edition because we did have this milestone of 10 years from the Jobs Act. It's amazing that it's now been 10 years since the Jobs Act was enacted. Well, everybody obviously should read this book, but lawyers at firms, of course, securities lawyers, litigators, general corporate lawyers, I think in-house lawyers at investment banks, funds, companies would benefit greatly. It's a book that's written in plain English that is intended to be very, very practical. It's the book that I always wanted as an associate and never had.